Hi everyone, Michael Truman here. So today I'm going to talk about a couple of recent Supreme Court cases that have the potential to have a major impact on firearm rights and specifically the ATF. Those cases are called Loper Bright Enterprises v. Raimonato and Relentless Inc. v. Department of Commerce. So before I get into those specific cases and why they're important for gun rights, I want to lay the groundwork so that I think it'll give you a better understanding of what we're going to talk about with the Supreme Court cases. So, and again, some of this might be review for people, but it's good to lay this groundwork. So Congress passes laws. Obviously, they actually become law once the president signs them into law, but Congress is the legislative body. Agencies, which ATF is one of them, and there's hundreds of federal government agencies, they then enact regulations. So the way to think of it is Congress generally lays out the big picture, but they often leave the details and the mechanics to the agencies to fill things in. So for an example, one thing I frequently deal with in ATF compliance is federal firearms licensed dealers, FFLs is the acronym, are required to maintain an acquisition and disposition book. And that's basically how they track guns that come in and guns that go out, and it's useful for tracing purposes. So 18 USC 923 says that licensed gun sellers must maintain a record of their acquisition and disposition of firearms. There's nothing in that law about the timing or the mechanics. ATF then enacted a regulation that builds on that law that says dealers must record an acquisition of guns by the close of the next business day following the receipt, and when they dispose of a gun, they must record that within 7 days. So if you're ever looking at something and you want to tell whether it's a law or regulation, it's relatively easy. If you see USC, which stands for United States Code, in the law citation, then you know it's a law, and again, that's a law is something passed by Congress. If you see CFR, which stands for Code of Federal Regulations, then you're dealing with a government regulation. One thing to keep in mind, though, is even though one is technically a law and one is a regulation, is that they both have the force of law. So that's our groundwork, is we're talking about laws versus regulations. So the current Supreme Court cases, again, Loper Bright Enterprises v. Raimonato, and again, I might be messing up those pronunciations, but close enough that if you Google it, you should be able to find it. And the co-case is Relentless Inc. v. Department of Commerce. So both of these cases deal with regulation of commercial fishing, which obviously has nothing to do with guns. But what they are trying to do is overturn a 1984 Supreme Court decision called Chevron v. Natural Resources Defense Council. So the 1984 Chevron case, as it's called, in that case, the Supreme Court laid out a legal framework that has come to be known as Chevron Deference. As background, what that case was about was it was 1984. Reagan, the case was heard by the Supreme Court in 84. It had been filed a couple years earlier. Supreme Court cases take a while to work their way through the system until they actually get to the Supreme Court. But once President Reagan took office, obviously a big part of his platform was cutting regulations, and the EPA had changed its definition of source for air pollution to be less restrictive. So less things were considered to be sources of air pollution. And an environmental group sued, saying that the ATF's regulation and interpretation was illegal. So the Supreme Court said that no, they were going to basically defer to the EPA's ruling and interpretation, and that came to be known as Chevron Deference. And what Chevron Deference today says, it says that courts should defer to an agency's answer or interpretation of law as long as, one, Congress has not spoken directly to the issue. So if Congress speaks directly to an issue, that would overrule anything that an agency would say, because Congress is the one that actually sets the laws and makes laws, and laws trump regulations. So again, number one, Congress has not spoken directly to the issue, and number two, that the agency's answer or interpretation was not unreasonable. So basically, What that does is it stacks the deck in favor of the ATF. All that they have to do is show that Congress hasn't directly answered the question and that the agency's answer was not unreasonable. So back to my example about an acquisition record for FFLs. Again, as I mentioned earlier, you have an FFL under the regulations has to record the acquisition of a gun by the close of the next business day. If someone challenged the law and said, I don't think it's legal to say that you have to wait until the end of the next business day to record an acquisition, a court could look at that and say, well, Congress hasn't directly answered the question. All Congress said is that you have to maintain a record of acquisition and dispositions. And two, is the end of the next business day reasonable? As long as it is, ATF wins. So, as far as the current status of the combined cases right now that are trying to overturn Chevron, there was oral argument in the Supreme Court back in January. And what oral argument means is that basically all of the attorneys have filed their briefs, and the briefs are where everybody really lays out all of their legal arguments. These briefs are they're very long, highly detailed, complex documents, and then the Supreme Court will set oral argument where attorneys will come in and argue their briefs, and it gives the Supreme Court justices chances to ask questions, probe the arguments, and just get more information about the case before at some point, generally months later, they actually issue their decision. So in the Supreme Court, the oral argument, the main argument that supporters have, I think there's really two, and by supporters I mean people who want to keep Chevron deference. They say that agencies are the experts and thus that courts should defer to them. And I can say that, I've been involved in cases against ATF in federal courts where, ATF generally does have a good understanding of guns and how guns operate in the firearms world, as opposed to a judge that doesn't know the first thing about guns. Again, I've experienced that personally where it was a judge that I don't know for sure if they've ever handled a gun, but it was pretty clear from my interactions with the judge that they had absolutely no idea about firearms. So again, the people who like Chevron deference, they'd say, well, we have these agencies, the EPA in environmental cases, the ATF with guns, the DEA with drugs. We have all these agencies, and we should just, generally defer to the experts, again, unless they're actually doing something that's unreasonable. The other argument that the supporters of Chevron deference made, to put it simply, is just precedent. So precedent refers to once a case has already been decided, generally you stick with whatever that case said. And Chevron, as I mentioned earlier, came out back in 1984. So we're talking about a case that's almost 40 years old. And the proponents of Chevron say, well, this has been part of the law now for over 40 years. We shouldn't disturb it at this point. The key part, though, for everyone to know is that the Supreme Court is not bound by precedent. The Supreme Court can always overturn a prior decision that it made. They're oftentimes hesitant to do so, but it can certainly be done. We all saw that relatively recently in the abortion cases when the modern case of Dobbs overruled the old case of Roe v. Wade from the 70s about there being a right to abortion in the Constitution. So those are really the big arguments on the side of Chevron deference. On the other side, and I think that this is the more persuasive argument, in all other contexts with the law, judges decide what the law is. They interpret the law and then issue their decisions. So, in the example where I talked about where you might have a judge that doesn't know firearms very well, it's up to the lawyers to educate the judge, and then again, the judge is the legal expert on the law, and they decide, what the interpretation is. Under Chevron, for example, if you followed Chevron deference, all 9 Supreme Court judges could say that a challenger's interpretation of the law is better than ATF's, but the agency still wins as long as the interpretation is at least reasonable, and that just doesn't seem right. Again, judges, in all these other ways, they are perfectly suited to determine what the best interpretation of the law is. Why should that not apply just because an administrative agency is involved? You also get into a separation of powers argument in that it isn't it's the judicial branch's role to interpret the law, not just defer to the executive branch agencies. As far as how I think the case is going to play out, you never know for sure with a Supreme Court case, but in trying to read the tea leaves from when I listened to the oral argument, as well as listening to other people who listen to it and reading articles and things like that, it definitely seems like there is a majority that is ready to overrule Chevron. It seemed pretty clear for sure that Justice Thomas is ready. Even in past decisions, he has been very critical of Chevron deference. Justice Alito seemed very on board with that as well. And again, it definitely seemed like the other justices, at least a majority of the justices, would be on board. Now, we'll see. As far as when that decision should come out, it'll probably come out sometime in May, or I think more likely in June. As far as the impact and how is this going to tie into firearms, how will it impact ATF? So just a recent example is the bump stock case. As background, bump stocks were banned when ATF changed how it interpreted the definition of machine gun. And again, so to see Chevron in practice, the definition of a machine gun is a law, which means it was passed by Congress. And the definition of machine gun is, in pertinent part, it's any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. So that's the definition as passed by Congress. It's then up to ATF to interpret that meaning and say which particular firearms or parts are already machine guns or can turn a regular gun into a machine gun. And that's where ATF now says that a bump stock would apply under that definition of machine gun to turn a regular gun into a machine gun. So a court applying Chevron deference would review and say, they wouldn't be saying, would the best reading of that machine gun definition say that it includes a bump stock? No. Under Chevron deference, they would just say, well, has Congress told us directly whether a bump stock is a machine gun or not? And the answer currently is no. And then they would say, well, is that interpretation just reasonable? Not, is it the best possible interpretation? So you can see the power of Chevron deference in that context. Now, even though overruling Chevron is going to impact ATF, it might not have quite as huge of an impact as you would think, because in the last couple years, the Supreme Court did not apply Chevron deference even in situations where in the past it might have been called for. And what people took that to mean is that they were kind of signaling that they didn't like Chevron deference, and agencies started to use other ways besides Chevron deference to justify their interpretations. Other judges have also said that Chevron doesn't apply in the context of criminal law. Other judges have also disagreed with that. The Supreme Court has never said for sure whether Chevron applies in the context of criminal law or just civil law. And then, even more importantly, in the context of the bump stock case, ATF actually did not claim Chevron deference should apply, but the court still analyzed the lower courts did analyze the issue, and the highest court decision said that Chevron deference didn't apply for two reasons. One, because ATF didn't claim it, and two, because it was in the bump stock case, ATF had originally interpreted the machine gun definition to say that a bump stock was not included, and then changed their minds, and the court said that in a situation like that where they are changing their opinion, that Chevron deference isn't warranted, which makes sense because you would have had Chevron deference for the original interpretation, and now you're trying to say that the complete opposite interpretation also gets Chevron deference. It doesn't make a lot of sense. The other case where this could have an impact right now is the pistol brace rule. And the pistol brace rule, ATF reinterpreted some prior interpretations to say that a braced firearm would be an SBR rather than just an everyday firearm. So that would mean you'd have to register it with the NFA. So again, there, the definitions of rifle and SBR did not change, but ATF changed its interpretation. And if that interpretation gets Chevron deference, it's much more likely to be upheld. So ultimately, if Chevron deference is overturned and the Chevron case itself is overturned, I think it will be what I would call a body blow to ATF. It will definitely put gun owners in a stronger position when they're challenging regulations, and it'll be a much more equal footing where courts are now for sure saying what's the best interpretation of the law, not just deferring to ATF. So I think it would definitely be a favorable outcome for firearm owners, but I wouldn't expect that all kinds of gun regulations are going to fall either. It's going to have somewhat of a limited outcome is what I would say. So definitely something interesting to pay attention to, and again, that decision will come out, if I had to guess, probably the last couple weeks of June. That's usually when the most major decisions come out. So everybody just, pay attention to Google. I think the best place if you're tracking Supreme Court cases specifically is a website called scotusblog.com. That's SCOTUS blog.com. They actually even post the oral argument so you can listen to the audio transcript, and when the decision comes out, they'll post the decision itself as well as some analysis of it. So a good place to keep yourself informed on the latest Supreme Court comings and goings. If anybody has any questions, feel free to post a comment, and we'll be back soon with another video.